All right. Welcome back. It's been a bit, but it's time. I hate that it's time, but it's time. We're getting back to DeCastro versus LVMPD, the Las Vegas Metropolitan Police Department. I promised I'd get to it eventually, and we're doing it now. So, for those of you who are new here, what took you so long getting here? But hi, I'm Joe. I'm an attorney. I'm licensed to practice in the state of Utah. This frivolous lawsuit we're covering is from my neighbor to the west, Nevada. So I can't remember exactly where we left off with this. It was June or July, somewhere in there. I couldn't take the stupid anymore. I had to take a break. And I still don't think the break was long enough, but there you are. Um, Either way, that we had a lot of nonsense litigation in that time. And I'm not going to do it. It doesn't matter anyway, because the we have the Second Amended Complaint, and that basically restarts us ground zero. That's where we're going. I make no promises to cover every single filing from here out, but we're gonna get at least a couple of them in. But so the important bits, scrolling through the docket. So on October 23rd, most of the case was dismissed. You may remember we did cover the motion to dismiss and the opposition and blah blah blah. So LVMPD did a 12b6 motion to dismiss for all the claims except the state law battery claims and assault battery, one other, I think. Basically, by saying he hit me in the nuts, there was enough to survive a motion to dismiss, a 12b6. So they didn't even bother. They were going to just do a summary judgment motion, and it would probably have been dismissed there, because 12b6, you go just off of the complaint. Those are the only facts for a 12b6. Summary judgment, both sides bring their facts, and you base it on the undisputed facts. And frankly, the body cam doesn't show him getting hit in the nuts, so it's not there. But either way, I haven't read the whole Second Amended Complaint, but I think he screws up strategically, because they're bringing a 12b6 for everything now. Spoilers. So looking at the last page of the order dismissing, so this is important. The following claims are dismissed with prejudice. The Fourth Amendment unreasonable search and seizure based on the arrest and search, dismissed with prejudice, can't bring it back. He's going to try, but he can't. He should be sanctioned. He probably won't be, but he should be. I would have been, but either way. So, false imprisonment, dismissed with prejudice. Invasion of privacy, dismissed with prejudice. Negligence based on the arrest and search, dismissed with prejudice, because the judge found that there was probable cause for the arrest. And Delete Laws is big mad over that. So the claims dismissed without prejudice, therefore leave to amend, equal protection. He doesn't have a chance on that, but either way. First Amendment retaliation, entity liability under Section 1983, Section 1981, and negligence based on biased policing. Craig Anderson did a bad job on defending that one. He should have been able to get it dismissed with prejudice, but he kind of skimmed over it. His mistake. But either way, or no, the supervisor liability is the one that he screwed up on, which was not dismissed because he kind of skimmed over it. And then all claims based on the alleged use of excessive force remain pending. So that's where we left it when, well, that's the state of the case when the judge ruled on the 12b6 motion. So clicking back to the docket, let's see. So he filed the Second Amended Complaint November 27th. That's the main course for today. But we are going to take a brief look at docket 64 from December 4th, the motion for reconsideration by Delete Laws. He did a motion to recuse the judge for bias, and it was worthless. The judge hasn't shown bias. Ruling against you isn't unlawful bias. The judge has to rule against someone. It's not an extrajudicial bias. It's not based on him knowing you. You're just a whiny little bitch that doesn't like that you got ruled against. So therefore, the court's biased and has to recuse itself. That's not the case. The court said no. So this was his motion for reconsideration of that, which he didn't bring anything new, which is what you need to do. New facts? No. It's just, but Your Honor, but there's one specific line. Well, he's got to go with the snark, and the defendants submitted their opposition to the motion to recuse, basically using the nope defense. Clearly, he's been watching people covering him, but that's not what I clicked onto this one for. So, memorandum of points and authorities. Although Judge Gordon's actions in this case, including finding facts that weren't there, would qualify as extrajudicial, a recusal based on apparent bias is not limited to extrajudicial conduct. Plaintiff doesn't merely disagree with the judge's adverse decisions. Now, this is the important sentence right here. Every reasonable law scholar that is following this case would be shocked. Should I say that one again? Every reasonable law scholar following this case would be shocked. Well, I've got a few things to say about that. So, clearly, because I don't agree with his legal analysis, that means I'm not reasonable. I'm biased. No. Like, yeah, I dislike Delete Laws. I think he's a tool. But I call it like I see it. Like, I dislike Josh Abrams just as much as I dislike Jose DeCastro. But he was in the right in DeCastro versus Abrams. And I said as much. I really dislike Josh Abrams. So there was no bias there. But YouTube, we're talking heads. What we think does not matter. We're not part of this case. Us getting our panties in a twist doesn't change anything, and it should not. It cannot change anything. This is not being tried in the court of public opinion. This is being tried in the federal district court for the District of Nevada. Period. End of story. This is not a YouTube case. This is a federal court case. So us being shocked is irrelevant. But once again, this is the no true Scotsman fallacy. It's, well, they're not reasonable law scholars, therefore we can discount their opinion. But here's what I'd counter with. I'm a lawyer. I'm not a law scholar. I'm sure Merb would say the exact same thing about himself. There's one other lawyer I know of who covers this case a little bit, Darcy. I've never interacted with him, but I'm sure he would say the same thing. Now, Paul Carroll. Hi, Paul, if you're watching. I know you're a lawyer who follows the case. You don't make videos on this case. Tell me in the comments, Paul, are you a law scholar or are you a lawyer? Because in my opinion, unless you're a law professor, you're not a law scholar, you're a lawyer, a legal practitioner. So I don't know of any biased or unbiased, reasonable or unreasonable law scholars following this case. There are lawyers following the case, legal practitioners, yes. No law scholars that I know of. There might be, I mean, I just don't know of any. But either way, our opinions are irrelevant. It comes down to the judge's opinion. His is the only relevant opinion at this point. If it makes it to a jury, it won't. But if it makes it to a jury, their opinions will matter too. But not on the law, only on the facts. Because the judge is the finder of law, the jury is the finder of fact. Get it? Good. So, with that, I really don't want to do this. It's gonna be awful and stupid, and he's terrible. But either way, I'm going to try not to make this a 4-hour stream, but just seeing 34 pages of nonsense from this dipshit. Ugh. I really... You guys better appreciate this, is all I'm saying. But Second Amended Complaint for damages and demand for jury trial. Jose DeCastro versus Las Vegas Metropolitan Police Department, State of Nevada. Brandon Bork, Jesse Sandoval, Erland Torrey, Chadley Dingle. That's a great name, Chadley. Brandon Sorensen, Clinton Doolittle, and Sitco, and a Doe's 1 to 50 inclusive. Now, he's added this defendant Sitco. We don't have service to anyone named Sitco. It's based on a different event. We'll see. It's nonsense. Clearly, he hasn't learned what the 11th Amendment is yet, because he still thinks he's suing the state of Nevada, despite the state of Nevada having sovereign immunity. Now, you can sue the governor of the state of Nevada in his official capacity. You can sue the attorney general of the state of Nevada in his official capacity. And I say his, I don't know who the governor or attorney general are, but either way, you can sue them in their official capacity. That's how you sue the state of Nevada. The state of Nevada is immune. But, you know, I'm just a biased, what was it? An unreasonable non-law scholar, and he's a 20-year law scholar, so he knows. Oops, wrong one. Introduction. Plaintiff, a member of the press who specifically records police interactions, was recording a police officer interaction outside of a Roll and Smoke barbecue in Southwest Las Vegas, Nevada. 5 Las Vegas Metropolitan Police officers, including the officer that he was recording under the guise of protecting the privacy of another citizen in public, without reasonable suspicion that the plaintiff was involved in any criminal activity, did interfere with and rob plaintiff of his liberties while he was in a place that he was lawfully allowed to be. While plaintiff was performing constitutionally protected activities. The officers detained plaintiff, handcuffed him, arrested him without a warrant, battered, tortured, forced him into the back of a patrol vehicle, and searched him and his possessions. None of the defendants intervened to prevent the unreasonable detention, arrest, battery, torture, or searches. So he said, like he still doesn't understand. Like, I guarantee he's going to be bitching about this in the future, in future pleadings. But because he's going to say, well, I put it in my complaint, therefore it's true. But he still is doing the conclusory statements, which is why I have for a year now have been calling him Captain Conclusory. I mean, I don't know. I assume he's accusing the police of trying to protect the privacy of the citizen in public. That's irrelevant. That's irrelevant. It was, were you interfering in their stop? So, without reasonable suspicion. Now, when they moved to dismiss because they had reasonable suspicion, the judge has already ruled that there was reasonable suspicion. The judge found reasonable suspicion based on the pleadings. Because what is reasonable suspicion? It's a conclusion of law. The judge found, as a matter of law, there was reasonable suspicion to arrest him. So, number one, you've already lost this. Number two, this is a conclusory statement of law. It isn't afforded the benefit of, being considered the truth for the purposes of a 12b-6. You were lawfully allowed to be there. You were not lawfully allowed to be on the scene of a criminal investigation, even if it's a traffic investigation. If you are too close, you can be told to leave. And once again, conclusory. This is a conclusion that you were performing constitutionally protected activities. Now, yes, filming the police is a constitutionally protected activity. You have a First Amendment right to film the police. You do not have the right to interact with the police while they are conducting a traffic stop. That's interfering. You do not have the right to talk to the subject of that police stop. That's interfering. You do not have the right to stand too close. That's interfering. You can film from a reasonable distance without interfering. That's not a difficult concept. It's not a difficult concept at all. But he still doesn't get it. Sadly, the abusive treatment plaintiff endured for merely asserting his rights and recording the police while brown is not unusual or surprising. Although the citizens and legislators of Nevada want police reform, these defendants think that they can continue their old ways. These defendants continue to enforce their feelings instead of the law, and continue to force respect instead of earning it. This civil rights action seeks to vindicate plaintiffs' constitutional and statutory rights and hold the officers and their department accountable for biased policing practices and the policies, or absence of policies, that resulted in these practices. I mean, while brown, you have a Hispanic name, but you're as white as I am, dude. They commented on your lips being white. They thought you were on drugs. Dry white lips, that's a sign of the, certain marching powder, if you get my drift. And the citizens and legislators of Nevada want police reform. Well, if the legislators wanted it, they'd have it already. But this is irrelevant. Completely irrelevant. Even if true, it's irrelevant because they are policing based on the laws of the state of Nevada as they are currently written. If you want changes, get it changed. Don't complain that they're doing it within the law now. But and I get so sick of these First Amendment auditors. You're not the feelings police. That this isn't policy. This is unfortunately, Delete Laws feels that he has the right to interfere with police stops. That's the feelings involved here. The officers, now, officer safety is, in my opinion, taken too far on fairly regularly. It's too broad an excuse. Now, if you have someone standing on your crime scene interfering with your traffic stop, officer safety is a valid concern. They do need space to work. They need space to work. It's a real easy concept, but once again, parties. Plaintiff Jose DeCastro is an adult over the age of 18, a member of the press, and at all times relevant hereto was and is a resident of the state of California. DeCastro is a non-white person of color of Colombian Jewish descent. Press X to doubt. I mean, I've seen the discussions about his Jewish descent, that he apparently some Portuguese in the past, like 600, 700 years ago, there were Portuguese DeCastros who were Jewish, and therefore he is of Jewish descent. Even though, he only started claiming Jewish descent in the last year, and he's raised Catholic, and depending on which way the wind is blowing, he's Catholic, he's Jewish, he's atheist, he's spiritual, whatever. It's these people really drive me nuts. That it's like, I don't care if someone is religious. I've said it before. I'm not. I jokingly started the Reformed Church of Pastafarianism, the Linguini. We worship the Grand Linguini. The flying spaghetti monster is real, but he's a dick. So we go with his brother, the Grand Linguini. But it's, if you're going to use religion as a shield, use your religion as a shield. Don't pick one at random for whatever suits you at that given time. That's a scumbag move. Defendant, Las Vegas Metropolitan Police Department, LVMPD, is a quasi-municipal entity and a political subdivision of the state of Nevada, created and regulated by NRS Chapter 258, and at all times relevant hereto, employed all of the individually named defendants. Defendant, State of Nevada, is a government entity and at all times relevant hereto, operates, oversees, and manages defendant LVMPD under the color of state law. Now, the state of Nevada is a government entity. It's a sovereign entity. The state of Nevada is sovereign. What do sovereigns have? Sovereign immunity. Sovereign immunity. 11th Amendment. It's a bitch. Defendant Brandon Bork is, and at all relevant times was, an officer with the LVMPD. In doing the things herein alleged, Bork was acting under the color of state law and in the course and scope of his employment with Nevada. Bork is sued in his individual capacity. You fucking moron. He's sued in his individual capacity. So you're not suing him in his official capacity or in his official and individual capacity? You're just suing him in his individual capacity. So if you're just suing him in his individual capacity, why would his superiors be on the hook? He has no superiors as an individual. You're just suing in his individual capacity. Stupid, 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 stupid. It's not gonna matter, but it is stupid. Oh, I'm going to try to remember to cover this. Hopefully tomorrow I'll do the motion to dismiss. And I'll try to bring it up then. But it just popped into my head. It just popped into my head. And so let's have a little fun. Let's have a little fun. Let's have a little fun. So the timing of the motion to dismiss was beautiful, if you ask me. And here's why. Here's why. So we know that delete laws has had trouble meeting deadlines recently. Like I mentioned that I wasn't going to go over everything, but let's just look at number 60 here, just for shits and giggles. Plaintiff Jose DeCastro respectfully moves this court for an extension of time to file a Rule 59E motion to reconsider. Plaintiff needs 14 days to finish the Second Amended Complaint due to work obligations getting in the way, traveling for the holidays, and the sheer amount of work involved in amending the complaint and in arguing all of the legal and factual errors. Poor put on delete laws. bringing frivolous lawsuits and then complaining that they're too much work for little schnookums to handle. Well, here's why that is hilarious. Just the funniest shit. So he brought the Second Amended Complaint on November 27th. So 21 days to respond. 21 days to respond. Rule 12. 21 days. So November 27th, it would have been due on December 18th, if my math is correct. So instead of waiting until December 18th, LVMPD filed the motion to dismiss an entire week early. A whole week early. Now, why is that hilarious? Because now his response is due on Christmas. I mean, either way, if they had waited, it would have been due on New Year's. But it's due on Christmas. Merry fucking Christmas, bitch. That's hilarious. I love it. I mean, it is golden. Absolutely golden. But it gets better. It gets better. Why does it get better? Because remember, we looked at docket 64, the motion for reconsideration. Now, the response was due today. Well, not today, yesterday. It was due the 18th. And remember, I'm recording this right around midnight, so it'll be 2 days when you guys see this. But either way, it was due the 18th. It was filed the 18th, the response. If Delete Laws wants a reply, and we know he's going to want a reply because he must have the last word. He's terminally incapable of not having the last word. But when is a reply due? It's due on Christmas. Oh, he's gonna have a busy Christmas Eve. Merry fucking Christmas, bitch. I love it. I absolutely love it. This was absolute gamesmanship by Craig Anderson filing the motion to dismiss on December 11th instead of the 18th. It was golden. I love it so much. It's hilarious. It is absolutely hilarious. Comedy gold. I couldn't have done it better myself. It's just absolutely golden. Defendant Erland Torrey is, and at all relevant times was, a supervisor with the LVMPD. In doing the things herein alleged, Torrey was acting under color of state law and in the course and scope of his employment with Nevada. Torrey is sued in his individual capacity, including in his capacity as a supervisor. So, in his individual capacity as a supervisor, not his official capacity as a supervisor, doesn't make sense. It's almost like it's a moron toddler litigating things he doesn't understand. So either way, defendant Chadley Dingle is an officer. Brandon Sorensen, officer. Jesse Sandoval is an officer. Clinton Doolittle is an officer. And LVMPD officer Sitco is, and at all relevant times was, an officer with the LVMPD. In doing the things herein alleged, Doolittle was acting under the color... Wait. Sitco, but Doolittle was acting under the color of state law. And in the course and scope of his employment with Nevada, Doolittle is sued in his individual capacity, but plaintiff does not know the full true name of Cisco. Thong, 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 thong. Terrible song, but he is an LVMPD officer that identified himself as Cisco 17673 at the incident in January 14th, 2023 video. Now, what he's trying to do is he's trying to show, look, see, it's a pattern in practice. They harassed me in January and they harassed me in May. I got him. It's not going to work. He's a moron. Like, seriously, IQ tests are complete nonsense. I'd love to see him attempt an IQ test. Do we think he'd get above an 80 on it? I mean, how many points do you get for writing your name? He's dumb. The true names and capacities, whether individual, corporate, associate, or otherwise, of defendants sued herein as does 1 through 50, inclusive, are unknown to plaintiff, who therefore sues said defendants by such fictitious names. I mean, which corporate entities would you even be suing? Do you want Rollin' Smoke to sponsor you? Is that the corporate entity you're going after? Rollin' Smoke for letting LVMPD use their parking lot for traffic stops? Is that where corporate liability ensues? Bitch. A plaintiff will amend this complaint to show the true names and capacities if and when the same are ascertained. Plaintiff is informed and believes, and thereon alleges, that said defendants, and each of them, are responsible in some manner for plaintiff's damages as herein alleged. Each reference in this complaint to defendant, defendants, capitalized, or a specifically named defendant also refers to all Doe defendants. Does 1 through 5 are believed to be officers of the LVMPD. Does 6 through 25 are believed to be employees of the LVMPD. Does 26 through 50 are believed to be employees of the state of Nevada. Now, he says he's gonna amend to include them. If you're on your Second Amended Complaint, you're going to have to show good cause to the court why you get another bite at the apple. Court's not going to be putting up with your nonsense and shenanigans and tomfoolery much longer. Plaintiff is informed and believes, and thereon alleges, that each of the defendants sued herein was negligently, wrongfully, and otherwise responsible in some manner for the events and happenings as hereinafter described, and proximately caused injuries and damages to plaintiff. Further, one or more Doe defendants was at all material times, responsible for the hiring, training, supervision, and discipline of other defendants, including the individually named and Doe defendants. And having just watched the specific South Park episode last night, it took all my willpower not to say, "You lack discipline." It's a South Park joke, not a me joke. Don't come after me. And it's a little bit before my times, but the events and happenings. Isn't that what hippie gatherings in the 60s were? The happenings? I was clearly born in the wrong decade. Like, my musical taste starts really about 1962, matures in 67, and runs through 1980. Best band since then is Sublime by a large margin. Plaintiff is informed and believes, and thereon alleges, that at all times herein mentioned, each of the defendants, including all defendants sued under fictitious names, was the agent and or employee of each of the other defendants, and in doing the things hereinafter alleged, was acting within the course and scope of such agency and employment. No! We've discussed agency law before. You can't just allege, Doolittle is Bork's agent because I said so. There has to be an actual principal-agent relationship. You saying, well, I believe that they're agents of each other, that doesn't make it so. That's nonsense. That's utter nonsense. That's fictitious. It's complete BS. And they're co-workers. Sorensen is their supervisor, but that's supervisory liability, not agent principal liability. It's a different thing. Completely different thing. You don't know what you're doing. You are a moron. Just stop. Or at least, 10 pages maximum so that I don't end up tearing my hair out by the end of a stream. Plaintiff is informed and believes, and thereon alleges, that at all times herein mentioned, each of the defendants, including all defendants sued under fictitious names, was the agent and or employee of each of the other defendants, and in doing the things hereinafter alleged, was acting within the course and scope of such agency and employment. Once again, you're making shit up. Police officers aren't employees of other police officers. That's not a thing. You alleging it as a thing doesn't make it a thing. It's once again, it's a legal conclusion. Captain Conclusory. Plaintiff is informed and believes, and thereon alleges, that each of the defendants was at all material times an agent, servant, employee, partner, joint venturer, co-conspirator, and or alter ego of the remaining defendants, and in doing... Who the fuck wrote this nonsense? Haha! I'm not Doolittle, I was Sorensen all along. And I hope that was my headphones and not the audio cutting out. That's annoying either way, but this, it's not a masquerade ball. You don't rip off your mask and say, ha, I was Sorensen, not Doolittle. It's not alter egos and employee, partner, joint venturer, servant, public servant, as if that's a pejorative. So and in doing the things herein alleged was acting within the course and scope of that relationship. Plaintiff is further informed and believes, and thereon alleges, that each of the defendants herein gave consent, aid, and assistance to each of the remaining defendants, and ratified and or authorized the acts or omissions of each defendant as alleged herein, except as may be hereinafter otherwise specifically alleged. At all material times, each defendant was an integral participant, jointly engaged in constitutionally violative, unlawful, and or tortious activity, resulting in the deprivation of plaintiffs' constitutional rights and other actionable harm. At all, I think I need a new battery in these headphones. We'll see if switching off the noise canceling helps. At all material times, each defendant acted under color of the laws, statutes, ordinances, and regulations of the state of Nevada. Jurisdiction and venue. This court has jurisdiction over this action pursuant to 28 U.S.C. sections 1331 and 1343A 3 and 4, because it arises under the Constitution and laws of the United States, and it is being brought to obtain compensatory and punitive damages for the deprivation, under color of state law, of the rights of a citizen of the United States that are secured by the United States Constitution, pursuant to 42 U.S.C. sections 1981, 1983, and 1988. This court has supplemental jurisdiction over the claims arising under Nevada law, pursuant to 28 U.S.C. section 1367. So, people have brought up, isn't he actually a resident of the state of Nevada as of now? Probably. In fact, he did enter a notice of change of address. It's frightening how close his current change of address, although it's a UPS store, I believe, so a P.O. box. I don't know how close it is to the commercial property he's allegedly squatting in, but it's frightening how close his mailing address is to where my sister lived when she lived in Nevada. Like, we're talking easy walking distance, as long as it's not 110 degrees outside. I'd melt in Nevada. Seriously, I actually, I don't know this conclusively, but I think amputees have a harder time in the heat because, I have considerably less surface area to body mass as a proportion. So there's less surface area to dissipate heat from. And I think that's noticeable. This court is the proper venue pursuant to 28 U.S.C. section 1391b2 because the events giving rise to the claims occurred in the county of Clark in Nevada, which is in the U.S. District of Nevada. Oh, and I was going, before I went on the tangent about heat. So, yes, he has changed his mailing address to Nevada. And so you may say, but Joe, that means there's no diversity of citizenship, so the court doesn't have subject matter jurisdiction. It should have been brought in state court. Well, this isn't brought under diversity of citizenship jurisdiction. This is brought pursuant to, because remember, we've talked about jurisdiction before. Federal courts have jurisdiction to decide constitutional questions. So, Fourth Amendment, blah, 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 that constitutional. So federal jurisdiction. 1983, federal law, so federal question jurisdiction. And then the supplemental jurisdiction, basically, there's the state law claims, battery, unlawful arrest, not, those ones. Those are state common law torts. If they were brought on their own, in order to get them into federal court, you would need diversity jurisdiction. Here, you don't, because if it arises out of the same series of events so that it makes sense to bring in the same lawsuit, the court can exercise supplemental jurisdiction. And here, those state law claims that it otherwise wouldn't be able to hear. So that's why it's able to. And so you'll also notice he doesn't say anywhere in the jurisdiction section, he doesn't say anything about this lawsuit is for claims in excess of $75,000, because once again, that's irrelevant because it's not diversity jurisdiction, and $75,000 is the jurisdictional amount for diversity jurisdiction. General factual allegations. Big asterisks on factual allegations. On October 3rd, 2018, the Las Vegas Police Protective Association, of which defendants are members, released a training video titled Videotaping Officers and Being Legally Smart. In the video, David Roger, general counsel, says there are also people that want to bait officers into arresting them and scoring big settlements in civil cases. Roger further says, don't take the bait. Be legally careful. If they aren't obstructing your investigation, if they're not on top of you, if they're not putting you in danger, they're merely videotaping you, you have no basis to arrest them. If they aren't obstructing your investigation, then try to ignore them. I understand it's difficult. He goes on to say, you have an absolute right to tell them to stay out of the immediate area so that they are not a distraction or a danger to you. However, if they walk a distance away and they continue videotaping you, there's nothing legally you can do. And if you force the issue and arrest them, you could be sued civilly. And what's that whole video? What do we call that? We call that irrelevant. It's irrelevant. It's not a court decision. It's not legally binding. It's, what do frauditors say? That's policy, not law. This isn't even policy. This is advice. And even still, let's say this is the state of the law. You have an absolute right to tell them to stay out of the immediate area so they are not a distraction or a danger to you. Delete Laws didn't do that. He stayed too close and he was distracting. He was yapping at the officer. He was yapping at the Jane Doe. He wasn't merely videotaping. So, Nevada passed police reform statute NRS 171.1233 in 2020, preventing police officers from interfering with a person's recording of a law enforcement activity, including without limitation by intentionally preventing or attempting to prevent the person from recording a law enforcement activity or threatening the person for recording a law enforcement activity, or commanding that the person cease recording a law enforcement activity when the person was nevertheless authorized by law to record the law enforcement activity, or stopping, seizing, or searching the person because he or she recorded a law enforcement activity, or unlawfully seizing property or instruments used by the person to record a law enforcement activity, unlawfully destroying or seizing any recorded image of a law enforcement activity, or copying such a recording of a law enforcement activity without the consent of the person who recorded it, or obtaining approval from an appropriate court. Once again, that's irrelevant. You were not arrested for recording. You were arrested while you were recording. There's a difference. You were arrested for obstruction, for interfering. The officer even told you you could keep recording. You were allowed to record. You were not allowed to be where you were. You could move back to an appropriate distance and record to your heart's content. If that's not close enough, get a shotgun mic. Get a zoom lens. There are other things other than the built-in iPhone camera and microphone. I mean, these morons claim, well, I have to be right up your ass because otherwise I can't hear, and I have the legal right to hear everything you say on your traffic stop. You don't. You don't. You have the right to record it, but the officer can talk real quietly. That's not prior restraint. That's not violating the First Amendment. He can turn to the side and do sign language. I can't do sign language, but either way, he can speak in German. You don't have the right to understand. You don't have the right to hear. You don't have the right to see. You have the right to film. And if you are not able to film of a sufficient quality from where you're legally allowed to stand, get better equipment. Your terrible equipment isn't the police violating your First Amendment right to film. On February 25th, 2021, the Las Vegas Police Protective Association, of which defendants are members, released an update to the above training video titled Recording Officers. And I meant to mention this the first time he said, the Las Vegas Police Protective Association. How does he know they're members? This is just a conclusory statement. Is this something that you're automatically a member? Is this the police union that you're automatically a member if you're in the police? Or is this like sovereign citizens? You attorneys, you're members of the American Bar Association. That makes you evil and corrupt and blah, blah, blah. And it's like, the American Bar Association is an optional trade association. Attorneys don't have to be a member. I actually do pay money every year to be a member, but I do it because that's one of the cheapest way to do my continuing legal education hours. But that, once again, this is just Captain Conclusory striking again. In the video, Roger says, in our last special session, the legislature passed NRS 171.1233 as part of police reform. And this statute guarantees citizens an absolute right to videotape police officers, and police officers are not allowed to do anything to stop their recording or to seize their cameras, with one exception. And the exception is that a person recording your activity cannot interfere with your investigation. Here, he goes on to say, really, that means that they can't physically get within your space, which jeopardizes your safety or another citizen's safety. He finishes with, so the takeaway from this is obviously that if people are videotaping you, you can't do anything to them. However, your safety as citizen's safety comes first, and you can order a person to give you more space in order for you to do your job. So once again, Delete Laws thinks this helps him. This is exactly contrary to what he did, though. And I think the reason he's posting these, the transcripts of these videos, is for his Monell claim. The see, they have an illegal pattern and practice, and it's like, but if you're saying this is their training, which you haven't properly alleged anyway, you've just conclusorily stated that they're members of this association with no proof, but you've conclusorily stated they're members of this organization and that this is the training they receive. And the training they receive is to let people film unless they're obstructing or a danger. So if this is the training they receive, there is no Monell liability because this is the official practice. This is the official policy, according to you. Unless you're trying to say, well, they don't follow that policy, so that's where the Monell liability comes in. The problem with that is, of course, they did. They told him, keep filming. Go right ahead, film. You have to move back, though. That's what they told him to do. Where in this? Where in this does it say you can't tell a videographer to move back? Nowhere. Nowhere. It says you can't stop them from filming. It doesn't say you can't tell them to move back. The LVMPD has a written misdemeanor arrest policy that a person will not be arrested for a misdemeanor unless there is a reasonable cause to believe that the violation for which the person is arrested will continue. However, an arrest shall not be made in lieu of citation on the basis of a mere speculation that the person might commit a new crime upon release, whether of the same or of a different nature, i.e., offense such as shoplifting may be repeated at some time in the future, but there is no reasonable certainty that this will occur. Therefore, in the absence of other exceptions, to the citation criteria, shoplifters and most other misdemeanors will be cited. Once again, this is conclusory. He says there's a written misdemeanor arrest policy. Provide it. Where? But assuming this is the case, won't be arrested unless there is a reasonable cause to believe that the violation for which the person is arrested will continue. Sorensen, the supervisor, said himself on body camera, the reason we are arresting you instead of citing you is because we believe if we simply cite you, you are going to continue this the rest of the night. If we don't arrest you, you're just going to follow us from one stop to the next. Which was a reasonable assumption, but that's exactly what the exception is, according to Delete Laws. So even if we take him at his word, the exception applied. He's a moron. The LVMPD has a written de-escalation policy that says officers will make efforts to control a confrontation and not allow it to escalate. Additionally, Nevada passed police reform statute NRS 171.1455 in 2020, requiring de-escalation techniques and alternatives to the use of force whenever possible. And de-escalation, it was handcuffing you, putting you in the back of the police cruiser, arresting you. De-escalation doesn't mean saying get lost or keep doing what you're doing. Besides which, de-escalation is a two-way street. Yes, the police have the duty. They need to de-escalate. Frankly, lots of police need to do a better job of de-escalating. Now, what I see from frauditors and sovereign citizens and professional agitators is they're gaslighters. They pull this out of the abuser's handbook. They go and cause a confrontation. They get loud and belligerent. And when the cops go to arrest them, you have to de-escalate. The arrest is the de-escalation. It's just, it's abuser 101. The LVMPD has a written use of force policy that says officers will only use a level of force that is objectively reasonable to safely accomplish a lawful purpose and to continuously reassess their response and adjust any use of force accordingly based upon the level of resistance encountered. Further, any officer present and observing another officer using force that is clearly beyond what is justified or objectively reasonable under the circumstances will intercede to prevent the use of unreasonable force. Additionally, Nevada passed a police reform statute, NRS 193.355 in 2020, requiring officers to intervene when a peace officer observes the use of physical force that is not justified or reasonably should have observed the use of physical force that is not justified. What use of force can you use to arrest someone? Because he was under arrest. He actively resisted the arrest. They went to put him in handcuffs. He pulled away. They could have used more force to effectuate the arrest than they actually did. Now, they handcuffed him. They put 2 sets of handcuffs. We saw on the body camera video, he was able to have both wrists on the front plane of his body. He couldn't bring his hands together, but both wrists were on the front plane of his body. They used, frankly, the minimal amount of force that they could have used for an arrest. So once again, you're bringing up all these policies, but they weren't violated. They were followed. The LVMPD has a written interactions with public policy that says members will be courteous, patient, and respectful in dealing with the public. Members should avoid answering questions in a short and abrupt manner and should not use harsh, coarse, violent, profane, insolent, indecent, suggestive, sarcastic, or insulting language. Members should maintain professional demeanor regardless of the provocation. And that's completely irrelevant. The cops were professional. They were professional. You don't have to be nice to be professional. Officer Bork told him to move back. Don't interfere with my traffic stop. That's professional. It's justified, period. The Nevada Supreme Court ended qualified immunity as a defense to violations of the state constitution in Mack versus Williams, Nevada Supreme Court, 2022. But there's still discretional immunity and there's qualified immunity to the federal charges. The Nevada courts have found that discretionary immunity under state law does not apply to decisions regarding the amount of force to use or acts taken in violation of the Constitution. Vasquez-Brenes versus LVMPD, District of Nevada, 2014. So he says the Nevada courts, but these are all federal courts, you know, District of Nevada, federal court, Ninth Circuit. Oh, there's a Nevada Supreme Court, Ninth Circuit. As of 2017, the constitutional right to be free from retaliation while recording police activity in a public place has been clearly established in the Ninth Circuit. That's Redmond versus San Jose Police Department, Northern District of California, 2017. And Navid versus City of San Jose, Northern District of California, 2016. Addison versus City of Baker City, Ninth Circuit, 2018. And Askins versus Department of Homeland Security, Ninth Circuit, 2018. Now, he says as of 2017, it's clearly established in the Ninth Circuit, but it's not. That is a false statement. It's clearly established in the Northern District of California. And that's even assuming he's right. I go on the assumption he gets case law wrong because, frankly, you rarely see him get case law right. And if I'm going to look up case law, this will be a 5-hour stream, and I don't want to do that. But either way, at best, it's since 2018 when the Ninth Circuit ruled. Because Northern District of California is in the Ninth Circuit, but that's not binding precedent outside of the Northern District of California. We don't even know, without looking at it, that it's even binding precedent in the Northern District of California. It could be stamped not precedence, not for publication. That doesn't mean he'd put not for publication on his citation, even though he should. But so it might not even be. And, well, frankly, it's not published because this is a Lexis citation. Same with City of San Jose. So, yeah. At best, assuming he got the case law right, it's as of 2018. But once again, you were not retaliated against for filming. He told you you could film. He said it's fine. You just could not be where you were. As of 1995, the constitutional right to film matters of public interest has been clearly established in the Ninth Circuit. Fordyce versus City of Seattle, Ninth Circuit, 1995. Just reminding myself, these are the general factual allegations. Apparently, the supporting case law is general factual allegations. Which one of the Three Stooges do you guys think actually wrote this? As of 1990, the constitutional right to be free from retaliation for their protected speech has been clearly established in the Ninth Circuit. Ford versus City of Yakima, Ninth Circuit 2013, citing Duran versus City of Douglas, Arizona, Ninth Circuit 1990. As of 1992, the constitutional right to be free from a warrantless arrest without probable cause has been clearly established in the Ninth Circuit. Caballero versus City of Concord, Ninth Circuit, 1992. Gasho versus U.S., Ninth Circuit, 1994. And Beck versus City of Upland, Ninth Circuit, 2008. Once again, the court even found already that there was probable cause to arrest you. That's why Fourth Amendment, unreasonable search and seizures based on false arrest, dismissed with prejudice. False imprisonment, dismissed with prejudice. Invasion of privacy, dismissed with prejudice. Negligence based on the arrest and search, dismissed with prejudice. In fact, let's see. Let's find where we need to go. This is the ruling dismissing most of the Second Amended or First Amended complaint. Well, I'm going to go to the top and we'll do Control F. Well, let's do reasonable suspicion. It doesn't matter. The court found that there was reasonable suspicion. In fact, we'll actually go with the higher standard, probable cause. That's the better thing to search for. So the defendants contend DeCastro's Fourth Amendment unreasonable seizure claim based on the arrest fails because by the amended complaint's allegations, the officers had probable cause to arrest DeCastro for obstruction. They contend that DeCastro was too close to the scene, was interacting with Jane, who had no choice to avoid DeCastro because she was being detained by the police, and DeCastro would not back up when ordered to do so. Alternatively, the defendants argue that Bork is entitled to qualified immunity because no clearly established law put him on notice that it would be unlawful to arrest an individual who interfered in a traffic stop and refused to obey orders to back up. DeCastro responds that the defendants have improperly characterized the amended complaint's allegations. He did not allege that he was still close enough to interfere with Bork's interaction with Jane, and they had no probable cause to detain or arrest him for the undefined offense of obstruction. He also argues qualified immunity should be decided at summary judgment, not dismissal, to allay the risk. So this is qualified immunity stuff. So the plaintiff bears the burden of showing that the right was at issue is clearly established. We don't need that. So Qualified immunity should take place early. We don't need that, though. So, okay, the parties dispute whether the officers had probable cause to arrest DeCastro for obstruction. Probable cause exists when, at the time of arrest, the officers know reasonably trustworthy information sufficient to warrant a prudent person in believing that the accused had committed or was committing an offense. Even if the officers were mistaken that probable cause to arrest existed, they are nonetheless immune from liability if their mistake was reasonable. Even taking the amended complaint's allegations as true, the officers had probable cause to arrest DeCastro for obstruction. Nevada law makes it a misdemeanor for any person after due notice to willfully hinder, delay, or obstruct any public officer in the discharge of official powers or duties. By the amended complaint's allegations, Bork was in a police interaction with another member of the public, Jane. DeCastro started recording the incident on his phone, moved within 10 feet of Jane, and spoke to her. Although DeCastro obeyed Bork's first command to back up, Bork told DeCastro to back up further and threatened to detain DeCastro for obstructing, but DeCastro refused to do so. Bork thus had probable cause to believe that, after due notice, DeCastro was hindering, delaying, or obstructing Bork in the discharge of his duties. So, the court has said, even based on delete law's complaint, taking delete law's allegations as true, the officers had probable cause. So, when delete law says here in number 33 on the Second Amended Complaint, as of 1992, the constitutional right to be free from warrantless arrest without probable cause has been clearly established in the Ninth Circuit. But the court has clearly found that there was probable cause to arrest you. So bringing this up is completely irrelevant. The court has already made a ruling. It has dismissed with prejudice the unlawful arrest claim. With prejudice. So when you bring up as a cause of action false arrest, false imprisonment, whatever BS, you should be sanctioned. At some point, this mockery needs to cost delete laws money. Dismissal based on qualified immunity is not appropriate unless it can be determined based on the complaint alone that qualified immunity applies. O'Brien versus Welty, 9th Circuit, 2016. The qualified immunity inquiry is a fact-specific analysis and requires knowledge of all of the material facts of the specific context of the case. Saucier versus Katz, Supreme Court, 2001. The test set forth in Saucier distinguished in Pearson. Okay, so give us the test and give us the distinguishing test in Pearson. This is bad legal writing. Qualified immunity is usually inappropriate at the dismissal stage, even when construing the facts in the light most favorable to the non-moving party, because the court is often without sufficient facts to make an appropriate inquiry. See Morley versus Walker, 9th Circuit, 1999, finding dismissal based on qualified immunity inappropriate pursuant to 12b-6. But as the court found, now, I'm not going to cover this specifically, but this is the defendant's opposition to plaintiff's motion for reconsideration, the concerning delete laws trying to get the judge to reconsider his refusal to recuse himself. Well, let's find it. Oh, there was something I liked in here. So I think there's a better place where this is said, but a pro se complaint, however inartfully pleaded, must be held to less stringent standards. Okay, that's so. But pro se litigants in the ordinary civil case should not be treated more favorably than parties with attorneys of record. They say it better, I think, but that's not what we're here for. Okay, so one of the reasons Delete Laws thinks the court should recuse, that the judge should recuse himself, is because he was clearly biased in ruling that qualified immunity was appropriate, because he thinks qualified immunity shouldn't be decided on the motion to dismiss level. At best, it should be saved for summary judgment. But which is what we were just looking at in his complaint. So DeCastro next contends that, remember, this is the response from Craig Anderson, LVMPD. DeCastro next contends that the court erred in making a determination on whether the defendant officers are protected by qualified immunity on DeCastro's constitutional claims grounded in false arrest, both because he believes that the court reached the wrong outcome and because he asserts qualified immunity should not be determined at the dismissal stage. That's what we just read him say in the Second Amended Complaint. However, as noted in the motion for partial dismissal and the order, because qualified immunity is an immunity from suit rather than a mere defense to liability, the Supreme Court has repeatedly stressed the importance of resolving immunity questions at the earliest possible stage in litigation. Supreme Court, Hunter versus Bryan, Supreme Court, 1991. Consequently, qualified immunity can be resolved at the motion to dismiss stage if it can be determined, based on the complaint itself, that qualified immunity applies. That's O'Brien versus Welty, 9th Circuit, 2016. Here, the court was able to ascertain, based on the allegations in the First Amended Complaint, that the defendant officers had probable cause to arrest DeCastro and thus did not violate his constitutional rights by arresting and searching him. As a result, the defendant officers are protected by qualified immunity. There you go. Okay, this is the other thing that, so I love this headline here. Though pro se, this court is under no obligation to treat DeCastro more favorably than any other litigant. DeCastro further argues that the court erred in dismissing claims because DeCastro is pro se, and because the court pointed to factual allegations in the First Amended Complaint in determining that the pleading could not be cured by the allegation of additional facts. In making these arguments, DeCastro misunderstands the applicable standard for when dismissal with prejudice is appropriate. As a pro se litigant in a civil case, DeCastro should not be treated more favorably than parties with attorneys of record. See Jacobson versus Filler, 9th Circuit, 1986. The at-issue claims were not dismissed with prejudice because DeCastro's First Amended Complaint was inartfully pleaded, or because DeCastro failed to name the proper parties, but rather because the factual allegations pled by DeCastro with particularity demonstrated that probable cause existed for DeCastro's arrest. Therefore, the at-issue claims failed as a matter of law and could not be cured by amendment. I just they went at him hard there. And like as I've said, you First Amendment or pro se litigants, they're not held to the same standard, but they can't be treated more favorably. That's perfectly said. You can't construct a cause of action out of gobbledygook. Now, if it's inartfully pled, but they get the elements in there, you should construe it as being pled. Hence, the he punched me in the nuts is inartfully pled, but it's in there. So it survives the motion to dismiss. At least it survived the previous motion to dismiss. So, but once again, as we've seen, there is no excuse for failure to follow the rules. Although it seems that courts don't actually follow that standard, unfortunately. So back to the Second Amended Complaint. Arizona revised statutes, sections 13-33732. Why the fuck is he bringing up Arizona revised statutes? They are completely irrelevant here. They're completely irrelevant. He really is a complete moron. But Arizona revised statutes, a statute in Arizona making it illegal to record police within 8 feet was overturned on July 21st, 2023, citing infringement against a clearly established right to film police, specifically that it is not content neutral. The court had already issued an injunction against enforcement of the law as of September 2022. That's Arizona Broadcasters Association versus Brnovich, District of Arizona 2022. Now, that law, guess what? It was unconstitutional. We said from the start when it was passed that it was unconstitutional. But here's the thing. This statute being overturned as unconstitutional doesn't give you the right to record within 8 feet. It's reasonable. If you are too close to be reasonable, they can tell you to back up. Frankly, this was overbroad. It was overbroad. It was not content neutral. It was a bad law, period. Now, the thing is, there are times when you really might need to be within 8 feet recording. Now, you may risk arrest for it, but there are times when it's going to be necessary. Now, think Derek Chauvin and George Floyd. I think some of them were within 8 feet. I'm not positive, but that would have been illegal under the Arizona law. But it was clearly necessary. So that shows what a situation where this would have been overbroad, more restrictive than necessary, or even more restrictive than allowed. But if you are on the scene chatting with the detained driver, it's more than reasonable to tell you to back the fuck up. And once again, he never told you to stop recording. So the fact that, oh, well, in Arizona, the law making it illegal to record police within 8 feet was overturned. You were not arrested for filming. Get that through your thick skull. On January 14th, 2023, plaintiff premiered a YouTube video where he recorded a police interaction in a publicly accessible private parking lot between a man and his passenger, who are both people of color, and approximately 5 LVMPD officers. Officer Cisco was aware of plaintiff's camera and stood blocking the camera in violation of plaintiff's rights and NRS 171.1233. So apparently, police on the scene have to position themselves in places that are convenient to you. Your camera has the right to film wherever you want, and the police cannot stand between you and the subject. That's asinine. And once again, he's trying to show, number one, that, well, I haven't read this wholly in full, but he's either trying to show that these black men were treated differently than him because he's brown, or a pattern of illegal conduct against him violating his right to record. And apparently Officer Cisco or Sitco or whatever the hell it is standing in the wrong place is a pattern and practice of violating the right to record. So the officers were searching the man's truck because he'd allegedly not stopped long enough at a red light before turning right. The officers detained the driver and his passenger for over 40 minutes, where the police kept asking unrelated questions. Plaintiff never stood between a police vehicle and anyone detained, nor between a police officer and anyone detained. Plaintiff was not arrested. It can be inferred, based on past police conduct, that the 2 men of color were not arrested due to plaintiff recording the interaction. On my channel, this video got over 250,000 views. On larger channels, the video was viewed over 100,000 or 1 million times. Now, it can be inferred based on past police conduct that the 2 men of color were not arrested because delete laws recorded the interaction. So it's based on that one incident. And you don't know. You do not know. Just based on, let's go back up here. LVMPD has a written misdemeanor arrest policy that a person will not be arrested for misdemeanor unless there is a reasonable cause to believe that a violation for which the person is arrested will continue. So, failure to stop long enough at a red light turning right probably isn't even a misdemeanor. It's probably a traffic infraction. So not even a misdemeanor. So you say they were detained for 40 minutes asking irrelevant questions, blah, 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 blah. Well, if they didn't find anything else, why would they have arrested them for a traffic infraction? Whether you were there recording or not, it's irrelevant. It was a traffic infraction. Of course they would have received a citation instead of an arrest. I mean, Do you expect the cops to arrest them? Because if we don't arrest you now, you're just going to drive in circles around the block running that red light all night long. He is so stupid. He's ridiculous. And I just, what this has to do with him being arrested for something else. But see, I'm a class of one because you arrested me, a brown Colombian Jewish nincompoop, for something completely different, but you didn't arrest these two black men. How dare you? That makes me a class of one, and you violated my rights. Since January 14th, 2023, LVMPD officers communicated with each other about plaintiff's video and plaintiff's whereabouts, as evidenced by multiple incidents of LVMPD officers asking cop watchers if they were plaintiff. Some of these incidents have been recorded by cop watchers and published on YouTube. This is conclusory and it's irrelevant. It's irrelevant. The tracking and searching for plaintiff is circumstantial evidence that justifies an inference, and discovery will reveal that defendants conspired to unlawfully arrest and harm plaintiff. On February 25th, 2023, plaintiff premiered a YouTube video where he recorded a police interaction in a publicly accessible private Walmart parking lot on Charleston Boulevard in Las Vegas, Nevada. The interaction was between two police officers and a woman in handcuffs. One of the officers radioed in, "Control, be advised, we have a First Amendment auditor out here at our location." Plaintiff never came between a police vehicle and anyone detained, nor between police officer and anyone detained. Plaintiff was asked to step back, and plaintiff stepped back. Additionally, the woman in handcuffs said that she wanted to make a statement for the camera and explained how she offered to help a homeless person in the parking lot who was dehydrated and then was detained in handcuffs for it. Additionally, a paramedic politely asked plaintiffs to step away so that he could have a private conversation with his patient, the dehydrated homeless person. Plaintiff consented and moved away. Plaintiff was not arrested, even though he said to Officer E. LaJoy, "Shoo, little doggy." There were multiple people in the parking lot near the officers, including the woman in handcuffs, that were not arrested. It can be inferred, based on past police conduct, that the innocent woman in handcuffs was not arrested due to plaintiff recording the interaction. Once again, why is this relevant? Besides which, you moved back, so you weren't arrested. You see how that works? You follow the cop's orders and you don't get arrested for obstruction. Simple. At Roll Smoke, you did not follow Officer Bork's command to step back. You were therefore arrested for obstruction. Do you see the difference? You see the difference? And your camera does not matter. You say, "See, I record and you don't arrest other people, but you arrest me for recording." In both cases, apparently they didn't have probable cause to arrest. We don't know. We don't know. Frankly, he's a moron. He, I believe, is a liar. I don't believe his conclusory statement. But this doesn't show disparate treatment. It's ridiculous. And it can be inferred based on past police conduct that she wasn't arrested because of me. How can we infer it based on sample size of 1? Show us where they have arrested people for similar conduct with similar information where you weren't there filming. Once again, it's irrelevant. At approximately 4:30 p.m. on March 15th, 2023, plaintiff was in a publicly accessible private parking lot outside of a Rollin' Smoke barbecue on Grand Canyon Drive in Las Vegas, Nevada. So we are on page 11. The last line 19 of page 11 of a 34-page amended complaint. And we finally get to the incident at hand. Everything before that was preamble, was nonsense, was bluster, was filibuster. You didn't need 10 of these pages. You didn't need 10 of these pages. A 34-page complaint, unless it's really complex, is too much. This is too much. This is why I didn't want to do this and delayed and delayed and delayed and delayed, because I just can't. Plaintiff witnessed what looked to him like a consensual police interaction between a woman and Bork. Oh, so you decided all of a sudden here that it was consensual. Amended complaint. So looking at, this is the first amended complaint from all the way back in May. So plaintiff happened upon a police interaction between a woman sitting in a silver Hyundai Elantra and Bork, who blah, blah, blah. So back then it was a police interaction. Now it's what you witnessed, what looked to you like a consensual police interaction. But once again, back then, it was a police interaction. But let's see. So Bork told Jane to leave and started walking aggressively toward plaintiff. So I guess he told her to leave, not told her that she can leave, because saying you can leave would be a better indication that she was detained. But either way, it looked to you like a consensual police encounter. Nitwit. Bork was sitting in a Ford Police Interceptor with the LVMPD logo on it and the number 19084. Ooh, 1984. Conspiracists can ignore the zero in there. 1984, big brother. Bork is the conspiracy. Plaintiff does not know the woman's name, but will call her Jane. Plaintiff started recording the consensual police interaction on one of his phones, making sure not to become between Bork and Jane or the police interceptor and Jane. So that just Captain Conclusory. I started recording the consensual police interaction. Captain Conclusory. Because if it's consensual, then I couldn't interfere. I couldn't obstruct a consensual interaction. That's what he's going after here. That's what he's going after here. If it looked consensual to you, ooh, I like it. Okay, you'll notice there's something missing. There's something missing. Plaintiff started recording the police interaction. This is from the First Amended Complaint back in May. So, moved to a position approximately 10 feet away from Jane and making sure not to become between Bork and Jane, he asked her if she was okay or was good. Are you okay? What does that indicate to us? If he's asking you, are you okay? He does not think that it's a consensual encounter. He thinks that she is being detained. He thinks she is being harassed by Officer Bork. If you think it's consensual, you're not asking her, are you okay? Are you good? But that is missing from the new complaint, the Second Amended Complaint. The dishonest shit. Within 6 seconds, Bork left his vehicle, got plaintiff's attention, and told plaintiff to back up, and plaintiff stepped back. Bork said, "She deserves privacy. This is not your business." Bork had stopped giving plaintiff commands, and plaintiff inferred that Bork had conceded and was now happy with the amount of space that he had to work. Plaintiff said, "I'm a member of the press. Go get in your car and do your job, little doggy." Unlike Officer E. LaJoy, plaintiff witnessed, and the camera shows, that Bork became visibly upset and came after plaintiff. Based on the fact that plaintiff had just expressed his speech, it can be reasonably inferred that it was in direct retaliation for Bork's hurt feelings due to plaintiff's exercise of his free speech rights. Bork said, "You are being detained," to the plaintiff. Notice what else is missing here. Notice what else is missing here. Going back to the First Amended Complaint. So, within 6 seconds, Bork left his vehicle, got plaintiff's attention, and told him to back up, which plaintiff immediately did, giving Bork an additional 5 feet. Bork told plaintiff to back up again, or he would detain plaintiff, at which time plaintiff began asserting his rights to record the interaction, saying, "I'm more than 10 feet away. I'm a member of the press. I have a right to be here." Bork threatened to detain plaintiff for obstructing and said, "She deserves privacy. This is not your business." So, in the new complaint, the Second Amended Complaint, We don't get that. We get that delete laws moved back a bit, and delete laws inferred that I moved back far enough. Despite in his first amended complaint, he said that Bork told him, keep moving back. He left that out this time. Why? Because that shows he was obstructing. Shows he was obstructing. And it shows that it wasn't that retaliation for hurt feelings. It was for not following the commands. Bork told Jane to leave and continued walking aggressively toward plaintiff, as if to use force, and plaintiff took a step back to prevent any physical confrontation. Plaintiff continued to protest Bork putting his hands on him unnecessarily, but Bork was patently interested in manhandling plaintiff in some way and said, listen, I am going to put my hands on you. Bork did indeed intentionally and offensively contact plaintiff with his hands. While plaintiff was firm in his verbal tone, he never screamed or yelled. He never threatened Bork and never said or did anything that would have led a reasonable law enforcement officer to fear for their safety or to suspect that plaintiff committed or was planning on committing any crime. There were multiple people in the parking lot closer to Bork than plaintiff was that were not arrested. Plaintiff observed no evidence that Bork was engaged in the discharge of official powers or duties. Plaintiff was not given any due notice. The thing is, if other people got close, they were going about their business. They didn't linger. They didn't loiter. They weren't interfering. And you were given due notice. You were told to back up. That was your notice. The police don't have to put up crime scene tape to do a traffic stop. They don't have to put a sign on the top of their car, official police business in progress. This is your due notice not to interfere. The obstruction laws are your due notice not to interfere. And when the officer tells you you are interfering, back up, that is also your due notice that you are interfering. And when you refuse, he can arrest you. There is probable cause. Did you want a signed mailed invitation not to interfere? Is that what it takes? Is that what due notice constitutes? Plaintiff asked for a supervisor, and while continuing to protest against illegal detainment and against the use of unnecessary force, plaintiff offered to walk to Bork's vehicle, which seemed to be where the officer wanted to illegally detain plaintiff. As soon as plaintiff reached the vehicle, he was forcefully grabbed, even though plaintiff was cooperating fully, and told that he was being placed under arrest. Plaintiff witnessed no evidence of an investigation during the detention. Plaintiff was well over 8 feet away, the distance that a court in this circuit ruled was a distance within the clearly established right to be when recording police. And plaintiff was much further away than 8 feet. See, he is terminally incapable of understanding case law. The Arizona case did not say you have carte blanche to record within 8 feet. It just said the 8-foot law was overbroad. It said there are, you know, you can't is, unlawful. But it in no way has it said 8 feet is allowed. It did not say 15 feet is allowed. Yeah, I mean, First Amendment auditors love to trot out, I'm 15 feet away. I'm allowed to be here. I'm 20 feet away. I'm allowed to be here. I'm 8 feet away. I'm allowed to be here. Now, where do they get those? They get those from cases where someone was arrested for interfering or for doing something or whatever. And the court found, you know, in under these factual circumstances, in this case, it was reasonable for this person to be within this distance. And First Amendment auditors say, well, in that case, anyone can be within that distance anytime. But that's not what the rulings are. And this moron doesn't understand that. To make it clear to the illogical, failing to move back an arbitrary distance when a member of the press has the right to be close enough to gather the news is not obstruction. Is this asshole serious? To make it clear to the illogical? Are you calling the judge illogical because he found that there was probable cause that you were obstructing? You better be careful. You better be careful. And when a member of the press has the right to be close enough to gather the news. No, you don't. Show us. Show us one case that says the member of the press has the right to be close enough to gather news. Because it's not true. The press has no additional rights over any other citizen. Filming does not grant you access that you otherwise would not have. If you are too close for the officer's safety, he can tell you to back up, whether you are press, whether you are a circus clown, whether you are the president of the United States. If you are obstructing, you are obstructing. If you are unable to gather the news from the safe distance that the cops tell you to move to, get better equipment. Get a telephoto lens. They don't have to grant you access to gather the news if it's interfering with their stop. This is aggressively wrong. It is a misapplication of the law, a misstatement of the law, conclusory bullshit. Being too close to an officer so that he can't safely perform his duties could be obstruction given willfulness and due notice. But that did not occur, and there is and will be no evidence of it. Once again, You're making statements of law that don't, they're just wrong. They're wrong. The officer telling you to back up is your due notice. He doesn't have to send you a Hallmark card to tell you to get lost. He doesn't have to fly the Goodyear blimp over the scene with a sign saying, Jose DeCastro, move 5 more feet back. This is ridiculous, and it's not the law. You are misstating the law, and just because you are putting misstatements of the law in your complaint doesn't mean the court has to take it as the law. The court does not have to take misstatements of the law as fact. You still don't understand that, despite how many times it has been explained to you, because you are thick. But that is the case. If plaintiff obstructed by being too close for the officer to safely perform his duties, maintaining that minimal distance is the action of obstruction, not failing to move back further. Once again, that's a misstatement of the law. You don't get to make up the law. You are not governor. You are not a legislator. You are not a judge. You are a pissant that thinks he knows the law better than anyone else. But you don't. Similarly situated individuals would be ones at a similar distance, not necessarily ones that failed to move back further. No. Not unless they were obstructing. Not unless they refused to move back. If people just walked by on their way to the car because it was in a parking lot, they're not obstructing. They wouldn't have to be told to move further back. So easily distinguished that although when an officer makes it clear to a person that there is a perimeter that the officer needs that person outside of to safely conduct an investigation and tells that person that they will be arrested if they don't leave that perimeter, it may be due notice. However, when an officer tells a person that they will be arrested for obstruction if they don't respect the privacy of someone in public, that is not due notice. That is abuse of process. Except you are misstating the facts. You are making shit up. He never said he was arresting you for not respecting her privacy. He arrested you when you refused to move back. Plaintiff was arrested without probable cause and without a warrant, in violation of the misdemeanor arrest policy of the LVMPD, and immediately after exercising his First Amendment rights, showing a direct causal relationship. Additionally, Bork did not use any de-escalation in violation of LVMPD policy, even if he felt provoked, according to the LVMPD interactions with public policy. Plaintiff was patted down and placed in handcuffs. Plaintiff made defendants aware of a prior shoulder injury, and plaintiff was put in 2 pairs of handcuffs to adhere to his medical needs. Although later during the encounter, Sandoval would yank and squeeze forcefully on plaintiff's arm, over and over and over, hurting his arm and shoulder unnecessarily. Poor little schnookums. Plaintiff was soon surrounded by 4 different police officers, now defendants, where he continued to protest that they had no valid reason to detain or arrest him. The video of the incident shows Bork ask plaintiff if he is on drugs, where Bork says that he is asking because of the color of plaintiff's skin. Plaintiff said that he did not have a criminal record, and Bork entered his vehicle to type up a report. Well, for starters, that's a lie. We know Delete Laws has an extensive criminal record. Just because he says only felony convictions are a criminal record, he has a lengthy criminal record. But he gets to make up definitions, just like he gets to make up laws. So, no criminal record. But Bork did not say that he was asking because of plaintiff's color of skin, whether he was on drugs. He said, your lips are white. Is it because you're on drugs? Your lips and your skin are not synonymous. And besides which, he especially didn't say, you're brown. Are you on drugs? No, it was white. White lips. And the video of the incident shows Bork asking plaintiff. So this is kind of important. Delete Laws is incorporating the video by reference. So generally, for a motion to dismiss, you're constrained by the 4 corners of the complaint. Those are the facts. But if the LVMPD successfully argue he has incorporated the video by reference, the judge can watch the video and it will clearly show the lies. It will clearly show the inconsistencies. But they also, it doesn't matter that here he's still arguing there was no probable cause to arrest me. And it's better pled to some degree. It's all lies. It's all bullshit. But it's better pled. He's left out certain facts that the judge relied on to determine that there was probable cause to arrest him previously. So he's left those ones out. So, hey, you've got to rely on the 4 corners of the document. So you can't find that there was probable cause. Therefore, you can't dismiss this one. Except the court already found that probable cause. They dismissed with prejudice because of that probable cause. So the motion to dismiss isn't going to say, well, there was probable cause. No, instead it's going to say, this was dismissed with prejudice. So it's void. This cause of action does not exist. Soon after, Sandoval demanded that plaintiff look only straight ahead, and when plaintiff did not immediately comply, Sandoval began squeezing plaintiff's elbow, placing pressure on plaintiff's ulnar nerve. Specifically, Sandoval intentionally and deliberately and needlessly pressed his thumb into plaintiff's ulnar nerve to cause pain and permanent damage. Funny enough, it's not that you were looking, you were turning your whole body to look around. When you're in custody, the police get to control you. They get to determine where you stand, how you stand. You were under arrest. You, by fidgeting, were not complying. Plaintiff complained about the pain and protested against needing to look in a specific direction to have an arrest effectuated on him. Sandoval said it was within their policy to use pain compliance on ulnar nerves for people in their custody that did not comply with random commands that would grant complete dominion over another human being, from which way plaintiff's head could turn to his right to use speech or when he can blink. Now, I don't remember, it's been a while, like almost a year, but I don't remember Sandoval saying it was policy to use pain compliance on ulnar nerves. Pain compliance, I think I remember, but not specifically ulnar nerves. I could be wrong, though, because it has been a very long time. And don't worry, I came prepared with a second water bottle because I knew this would be a long one. Jesus Christ, we're only on page 15. I'm going to do my best to speed through. I don't need to comment on every inconsistency. You all know it's complete and utter tosh. Plaintiff did experience severe pain and paresthesia from the compression of his ulnar nerve by Sandoval. When plaintiff pleaded for help from the surrounding defendant officers, they completely ignored plaintiff. Plaintiff told them, "You're going to be sued for failing to intervene. I'm sitting here telling you this man is torturing me. Please ask him to stop." Plaintiff was ignored by all sworn peace officers on the scene, who are now defendants. Plaintiff's elbow was squeezed for approximately 15 minutes in total before plaintiff's pain tolerance forced him to move his elbow away from Sandoval. At some point, defendant Torrey, the supervisor, arrived on the scene and authorized the defendant's behavior as being within their policy. Torrey then stated that plaintiff should be arrested to discourage plaintiff's behavior, which included recording the police and exercising free speech. All the defendants on the scene knew that there was no reasonable suspicion or probable cause to suspect plaintiff of any crimes, but wrongfully believed that they were justified in detaining plaintiff for assertion of his civil rights and for refusing to cooperate with the defendant's feelings and ridiculous, unreasonable demands on a law-abiding citizen based simply on their archaic, abusive police practices and their code of silence, and not reason or statute. Bork engaged in profiling against members of the press when he stated that First Amendment auditors are known for dropping their phone, pulling out guns, and shooting at officers, which is preposterous and provably false. Let's see. Let's see. I don't know where it is in here. I know I said I wouldn't stop on every point, but this is an important one. This is the order dismissing most of the First Amended Complaint. Member of the press, political viewpoint. DeCastro does not respond to the defendant's argument that being a member of the press or expressing a particular political viewpoint are not protected classes for equal protection purposes. He therefore consents to the granting of this portion of defendant's motion. However, it does not appear that that amendment would be futile. I therefore grant DeCastro leave to amend this portion of his equal protection claim. Okay, so I thought, I mean, the press is not a protected class, but it looks like the court didn't explicitly state that. Of course, he's just making it up, basically, that the press is a protected class. Otherwise, he'd have case law saying, the press is a protected class. Sandoval said that plaintiff needed to be patted down again. Plaintiff protested that he'd already been patted down by 2 officers. Sandoval then spread plaintiff's legs uncomfortably wide and purposely and maliciously and with significant force struck plaintiff in the testicles with what felt like a closed fist. Plaintiff yelled in pain, "I can't believe you just hit me in the nuts." Plaintiff was forcibly placed into a police vehicle by defendants who pulled the seatbelt as tight as they could, knocking the air out of the plaintiff. Plaintiff again pleaded for help from surrounding officers, but he was ignored again. Sorensen made statements that attempted to get plaintiff arrested for NRS 202.487 for having his dog in a vehicle, even though plaintiff's animal was not in unsafe conditions. Plaintiff was searched and transported to Clark County Jail, where he would not be formally charged, but only released with citations, approximately 5 hours after the incident began. The citations are your formal charges, you numbskull. They are your formal charges. Why do you think you are facing court, you are facing trial in January for misdemeanor obstruction? Those were your formal charges. Just because you weren't brought before a magistrate to be arraigned immediately, you were not granted bail, you were just released with citations. That is still charged. And Sorensen made statements that attempted to get plaintiff arrested, but you weren't arrested. Charlie was given to your nephew. So this is irrelevant. This is completely irrelevant. And even if it wasn't irrelevant, if they determined that Charlie was in an unsafe condition, they could have arrested you. This was just them investigating whether he was in an unsafe condition, which is perfectly reasonable. It's perfectly allowable. In fact, I would argue the cops had a moral imperative to investigate that Charlie was safe and that he was kept safe, that he was either taken into custody of animal control for his safety or released to a family member or friend for his safety. It would have been an abominable failure if the cops knowingly left Charlie unattended in that vehicle for God knows how long. They did you a solid by waiting around for, frankly, an unreasonable amount of time to allow your nephew to arrive to take custody of Charlie. They could have just said, we're taking him into custody of animal control. You can pick him up at the pound when you're released. That would have been reasonable. That would have been completely allowed. That would not have violated your rights in any way. It would have kept Charlie safe, and it wouldn't have wasted the police time waiting for your nephew. The officer's actions left plaintiff in the position where he had to pay for a ride back to his vehicle, and did pay monies for such a ride. You could have walked. You could have had your nephew. You could have hitchhiked. You could have taken the bus. You could have rolled. You could have flapped your arms. On the arm that defendant squeezed, plaintiff was left with a severe bruise in his elbow area, continues to have paresthesia in his little finger and thumb, and requires ongoing medical care. Almost a month after the incident, Sorensen continued to harass plaintiff by warning him against violating NRS 202.487, although plaintiff has never left his pet in unsafe conditions. You were following Sorensen around for almost a month. Sorensen teasing you about it, taunting you not to leave Charlie, isn't a violation of your rights. This is completely irrelevant. You didn't need 34 pages. You should have not included all this irrelevant fluff. I realize you probably had a career as a fluffer in the past, but that doesn't mean you need fluff in your complaint. As a result of the defendant's actions, plaintiff suffered a deprivation of his rights and liberties, sustained physical injuries, and suffered physical pain, mental suffering, emotional distress, fear, embarrassment, and other general damages in an amount to be proven at trial. So, aside from any of the others, embarrassment, you'd have to not be a sociopath in order to feel embarrassment. I'm not a psychologist. I'm not a psychiatrist. I can't diagnose him as a sociopath. I believe he has sociopathic tendencies. I believe he is pathologically incapable of embarrassment. Because someone who can feel embarrassment would not do the shit he does. I would be mortified going out in public harassing people the way he does. At no time during the encounter with defendants did plaintiff do or say anything that would put a reasonable officer in fear for his or her safety. Following the incident, Bork claimed in a written incident report that the reason why plaintiff was arrested was for engaging with a detained driver, refusing to give an officer reasonable space to work, and refusing to obey lawful commands after being advised that he was detained. A detained person does not have to obey random commands, and their rights are only limited as to leaving. Citation fucking needed. A police officer's feelings about lawful behavior must be weighed against a citizen's rights. The defendant's behavior did not follow LVMPD's use of force policy and interactions with the public policy. The written report by Bork also claimed because DeCastro was physically uncooperative with officers, admitted to being in trouble numerous times in the past for similar reasons, and would not even allow officers to explain to him why he was detained or placed in handcuffs, we determined that he was not a good candidate for a citation and release. Because of DeCastro's actions, it was clear that his criminal behavior would continue in the area if police did not act. So right there, you included the citation to the police report saying why you were arrested for a misdemeanor despite the misdemeanor arrest policy. Because this paragraph right here is clearly with it follows that policy. It's allowed. Plaintiff did not admit to being in trouble numerous times, but said the opposite. The facts in the written incident report contradict the video and were either fabricated or merely pretextual. Even if the facts set forth in Defendant Bork's report were true, which the video evidence disputes, those facts still did not give rise to a reasonable suspicion to detain plaintiff. Terry versus Ohio, Supreme Court, 1968. You'd think a nitwit such as Delete Laws, whose entire existence hinges around overturning Terry versus Ohio, would understand Terry versus Ohio is not even about reasonable suspicion to detain. Terry versus Ohio is about the Terry frisk, whether or not you can conduct a cursory search for weapons, pat them down. He doesn't even get that. And it certainly did not furnish probable cause to arrest plaintiff. And also, which the video evidence disputes. The video is within the four corners of his complaint yet again. Plaintiff stated early in the encounter that he had no criminal record and there wasn't any criminal behavior. At that point, a reasonable officer would have left the plaintiff alone. Bork never told plaintiff that there was an investigation or that he was interfering with it. Rather, Bork only demanded that plaintiff respect Jane's privacy in public and told you to move back. Defendant Bork seemed only intent on preventing plaintiff from recording the police interaction and retaliating because Bork's feelings were hurt by plaintiff's free speech. In addition, there appears to be a conspiracy by defendants to arrest plaintiff because he has recently covered several stories about LVMPD that went viral on the internet. Plaintiff is informed and believes and intends to prove after conducting relevant discovery that defendant's actions in detaining and or arresting plaintiff, using force on him, and illegally searching him and his belongings was motivated largely or entirely by the following. 1. Plaintiff's position as a member of the press that records police interactions for accountability and that was engaging in this First Amendment protected activity. 2. Plaintiff's negative viewpoint of police who all contribute to or hold silent the thin blue line about police brutality. 3. The color of plaintiff's skin. And or 4. Plaintiff's verbal protestations of the defendant's actions and plaintiff's accusation that the defendants were harassing him. They were harassing him. He wasn't harassing them. He wasn't following them around. They were harassing him by pulling people over around him and forcing him to videotape it. Such a conspiracy. And that's 4D chess, making him follow them around to videotape. I can't believe they'd do that to him. Indeed, as shown on the video footage captured by plaintiff's cell phone and the video footage plaintiff expects to obtain from the defendant's body cams, plaintiff did not do or say anything that would have provided reasonable suspicion or probable cause for the detention and or arrest, excessive use of force, and subsequent searches. Therefore, there is a strong inference that the defendants were, in fact, motivated by one or more of the four factors enumerated above. Well, hey, he's incorporated his video and the police body cam into his complaint by reference. And not that it matters, because it'll show that he didn't do anything that would have provided reasonable suspicion or probable cause for the detention or arrest. Except those claims have already been dismissed with prejudice because the court did find probable cause. Individual defendants submitted police reports that contradict the video evidence, including fabricated testimony. Is he serious here? Fabricated testimony? Fabricated testimony. Good thing complaints are allegations and not sworn testimony that would put you liable to perjury, just contempt of court. But let's wait on that. Let's see if he's signed this under penalty of perjury, which lawyers don't do. The combination of the various defendants' coordinated perjury and fabrication shows a strong inference of a plan by the defendants to deprive plaintiff of his rights under the First and 14th Amendments. Plaintiff has recorded approximately 10 police encounters of the LVMPD after the incidents in this complaint where plaintiff has not been arrested. Plaintiff would have recorded more encounters if he had not feared of again being unlawfully arrested for exercising his rights. So what you're saying is there isn't a pattern and practice of unlawfully arresting you. You've done it 10 more times after without being arrested. It was the one where you were too close and wouldn't move back, where you were obstructing, is the one where you were arrested. And after that, you were kind of a chicken shit and were shouting from a distance. Maybe that's why you were not arrested subsequent to this. LVMPD closed investigations into the incidents in this complaint, saying that no officers violated policies, even where it is clear that they violated their de-escalation policy, their use of force policy, their misdemeanor arrest policy, their training on dealing with people recording the police, and their interactions with the public policy. The officers also violated several statutes, including NRS 171.1233, 1455, and 193.355. Count one. Now, you'll notice. On this complaint, it's count one. On previous complaints, first cause of action, 42 U.S.C. Section 1983, Fourth Amendment, against Bork, Tory, Dingle, Sorensen, Sandoval, Doolittle, and Does 1 through 25. But now it's just count 1. Why do you think that is? I have a feeling it's because this was dismissed with prejudice. 42 U.S.C. Section 1983 was dismissed with prejudice. Right there. So, if he titles his causes of action in the new one, it's easier to see. Hey, this is the exact same thing that was already dismissed with prejudice. But count 1 has never been dismissed with prejudice because it's brand new. I've never brought count 1 before. I brought first cause of action. That's what was dismissed with prejudice. But count 1 is brand spanking new. So, plaintiff refers to paragraphs 1 through 73 of this complaint and incorporates by reference the allegations of said paragraphs as though expressly set forth at length at this point. Arrest without probable cause or a warrant under the Nevada Constitution, U.S. Constitution, federal statute, state statute, and common law against Bork, Sandoval, Tory, Dingle, Sorensen, Doolittle, and Does 1 to 5. That looks suspiciously like first cause of action. Count 1 looks like first cause of action, which was dismissed with prejudice. I would be severely sanctioned for this. At some point, the court needs to make this nonsense expensive. They need to sanction him. They need to. I don't know if Craig Anderson asked for it in the motion to dismiss or not. I hope he did. The factual allegations show that plaintiff was intentionally deprived of his liberty, that he was aware of his confinement, he did not consent to the confinement, and the officers lacked privilege or a warrant to confine him. Plaintiff was not willfully hindering, delaying, or obstructing any officer in their official duties. Plaintiff was simply standing there, exercising his First Amendment rights by filming the police in public. Finally, plaintiff did nothing to resist arrest, and in fact continued to voice his compliance. Defendants only needed to give him clear verbal commands and did not need to touch him for his compliance. Further, he says finally up here, but now it's further. Finally would be the final point. Further comes before finally. Dumbass. Further, even if plaintiff is found guilty of obstruction and resisting, it's only as a direct and proximate result of statutes being enforced or codified contrary to the civil rights guaranteed by the United States Constitution. Specifically, the statutes are being used in a non-content neutral manner to interfere with plaintiff's clearly established right to record the police in public. Except it is content neutral. Because you weren't arrested for filming. Despite how many times you say it, you were arrested for not moving back, for obstructing. Not moving back is content neutral. And he's heard us say so many times how when he's convicted in the criminal court, that just shows that there was probable cause, because it was, if he's convicted, that's reasonable doubt standard. But it's just, well, even if I'm convicted, you still should grant me damages, because I was only convicted of an unlawful statute that hasn't been declared unlawful, but I say it is, and you got to believe me because it's in my complaint, so it's taken as true. Plaintiff was harmed as a direct and proximate result of being deprived of his liberty for a period of time, being unable to do what he wanted or go where he wanted. Plaintiff also suffered mental injuries, including emotional distress, fear, and embarrassment. You say that, but once again, that is conclusory. Show us where you met with a psychologist, psychiatrist, counselor, any mental health professional. And since you're claiming this, if this survives a motion to dismiss, which this one won't because it's already been dismissed with prejudice, part of discovery is you're going to have to see a psychiatrist of LVMPD's choosing. Remember, in Depp versus Heard, Johnny Depp did not claim emotional damages, so he did not have to see a psychiatrist. Amber Heard did, so she had to, and it was put on blast. And that was fun. Defendant's malicious, oppressive, and despicable conduct. Yes, I am 2 years old, and I do enjoy you Looney Tunes. Carried out in a full and conscious disregard for plaintiff's rights and safety, entitles plaintiff to punitive damages and penalties allowable under 42 U.S.C. Section 1983 and Nevada law in an amount sufficient to punish and deter such conduct. Count 2. Unreasonable search and seizure. Let's see. Hey, that was dismissed with prejudice. Unreasonable search and seizure under the Nevada Constitution, U.S. Constitution, federal statute, state statute, and common law against Bork, Sandoval, Torrey, Dingle, Sorensen, Doolittle, and Doe's 1 to 5. The factual allegations show that plaintiff was arrested without probable cause and without a warrant, and so the subsequent search of plaintiff's person, including pockets, wallet, and cell phone, was a violation. Plaintiff was harmed as a direct and proximate result by the violation of his privacy, of the contents of his person, by the negative psychological and emotional impacts on his rights being violated, and the chilling effect that this had on the future exercise of his rights for fear of further abuse. Defendant's malicious, oppressive, and despicable conduct carried out in a full and conscious disregard for plaintiff's rights and safety entitles plaintiff to punitive damages and penalties allowable under 42 U.S.C. Section 1983 and Nevada law in an amount sufficient to punish and deter such conduct. Count 3. Excessive force in the course of an arrest under the Nevada Constitution, U.S. Constitution, federal statute, and state law, state statute, and common law against Bork and Sandoval. The factual allegations show that defendant Bork unnecessarily used force against plaintiff while he was being arrested, and that defendant Sandoval unnecessarily used force against plaintiff after he was already in custody. Plaintiff was harmed as a direct and proximate result by feeling physical pain and discomfort, negative psychological and emotional impact of being battered, and the chilling effect that this had on the future exercise of his rights for fear of further abuse. Plaintiff is still suffering physical pain and discomfort from the injuries that Sandoval caused him during the incidents in the complaint. Defendant's malicious, oppressive, and despicable conduct, carried out in a full and conscious disregard for plaintiff's rights and safety, entitles plaintiff to punitive damages and penalties allowable under 42 U.S.C. Section 1983 and Nevada law in an amount sufficient to punish and deter such conduct. Count 4. Defamation. Defamation. No. No. What? They didn't. No. This is ridiculous. This is preposterous. Cute Jackie Childs. This is absurd. Defamation under the Nevada Constitution, U.S. Constitution, federal statute, state statute, and common law. Against Bork, Sandoval, Torrey, Dingle, Sorensen, Doolittle, and Does 1, 2, 5. The factual allegations show that against Bork, Sandoval, Torrey, Dingle, Sorensen, Doolittle, and Does 1 to 5 did share false police reports with third parties. The totality of the facts further indicate that the defamation was done deliberately and maliciously, and that the defendants knew that the defamatory statements were about plaintiff and were asserted as the truth, even though they were false. Plaintiff was harmed as a direct and proximate result by this damaging of his reputation, which directly resulted in him, one, him being cited, and 2, criminal prosecution. The defamation also had a direct and proximate negative psychological and emotional impact on plaintiff. This is just utter nonsense. Police reports are not published. Someone pulling them as a public record is not publishing them. It's not defamation. This is not, will not, never will be defamation. This is preposterous. Count 5, chilling of First Amendment under the Nevada Constitution, U.S. Constitution, federal statute, state statute, and common law against all defendants. What exactly is this cause of action? Chilling of the First Amendment? It's made up. It's made up. That's what it is. It's made up. Chilling of the First Amendment is not a cause of action. You're making shit up. You need to be sanctioned. Count 6. First Amendment retaliation under everything. The facts show that while exercising his First Amendment rights, recording police under freedom of speech and freedom of press, and protesting against police misconduct, plaintiff did not do or say anything that would have provided reasonable suspicion or probable cause for the arrest, excessive use of force, and subsequent searches. The totality of the circumstances show that the defendants were in fact motivated by one or more of the 3 factors enumerated above. Blah, blah, blah. There was reasonable suspicion. There was probable cause. The court has already found probable cause. I can't. Count 7, Monell policy and supervisor liability claim under everything. The unconstitutional actions and or omissions of the defendants were pursuant to the following customs, policies, practices, and or procedures of defendants Torrey, LVMPD, and the state of Nevada and those 6 through 25, and which were directed, encouraged, and allowed and or ratified by policy-making officials with Torrey, LVMPD, and the state of Nevada, and blah, blah, blah. A, to carry out or tolerate unlawful arrests without probable cause. B, to carry out or tolerate detentions and arrests based on citizens' exercise of their First Amendment right to criticize and verbally protest officers' actions. See, I mean, he's just he's just conclusorily saying that these are policies, but they're not. The only evidence he has is one, when he was arrested. But he's given multiple instances where he was not arrested for filming. So it's not their pattern and practice based on his pleading. He's so slimy and dumb and awful. Count 8, selective enforcement and unequal police action under the Nevada Constitution, blah, blah, blah. And did he bring that one before? Not necessarily, I don't think, but either way, the totality of the allegations shows that defendants selectively enforced laws against people with white lips, against people with brown skin, against people that expressed criticism towards law enforcement, against those recording police interactions, and against those publicizing information on police misconduct. Except it doesn't. It doesn't. It just shows they asked you, why are your lips white? Are you on drugs? See, here he got the color of skin right, that people with white lips. They never once mentioned his brown skin, because once again, he's as white as I am. He's as white as I am. I just... Count 9, battery, which, once again, that one wasn't even subject to the motion to dismiss. It is to the next one. Count 10, invasion of privacy, which was dismissed with prejudice. I've got my handy little cheat sheet printed out. So he needs to be sanctioned. This was dismissed with prejudice. Invasion of privacy. Count 11, negligence, which they weren't negligent, but this one, I believe, was... Well, negligence was a mixed result, according to my cheat sheet. So, negligence based on biased policing was dismissed with leave to amend. Negligence based on the arrest and search were dismissed with prejudice. So, negligence, count 11, like I said, some of it was dismissed with prejudice, some leave to amend. Count 12, failure to intervene. I don't think that was a cause of action before. Either way, he's not going to win it. Count 13, civil conspiracy. He's definitely not going to win that one. It's, as I've said many times, many times before, that RICO, it's never RICO. RICO is the lupus of the legal world. That being a reference to the TV show House, where it's never lupus, except for the rare occasion where it is. But civil conspiracy, I count that as RICO. It's never RICO. except the rare occasion where it is. This is not one of those. Count 14, abuse of process. This lawsuit is an abuse of process. So, yeah, he's going to have a hard time with that one. Count 15, Monell. It's going to lose that one. It was not dismissed. Well, Monell was dismissed, but with leave to amend. And that's basically the entity liability. And finally, his prayer. Not a prayer for relief, just a prayer. As in, he hasn't got a prayer that this will work. Plaintiff prays for damages as follows. A, for compensatory damages in an amount according to proof. And B, for punitive damages in the amount of $5 million or in an amount sufficient to punish. Or sufficient to punish defendant's conduct and deter similar conduct in the future pursuant to 42 U.S.C. Section 1983. No punitive damages are sought against defendant Nevada. Well, that's nice of him since they have sovereign immunity. C, for all applicable statutory penalties. D, for attorney's fees pursuant to 42 U.S.C. Section 1988, which you don't have an attorney, so no attorney fees. E, for costs of suit. F, for such other and further relief as the court deems just and proper. And I mean, I'd ask for a specific amount in compensatory damages, especially if I'm asking for $5 million of punitive, because if he's given $1 of compensatory damages, $5 million would be illegal. He'd get $10, maybe, punitive. Demand for jury trial. Plaintiff hereby demands a trial by jury. Declaration of Jose DeCastro. I declare under penalty of perjury that the foregoing is true and correct. So, like I speculated a little while ago, this is under penalty of perjury. So he could be prosecuted for perjury. He's not going to be, but he could be because of all the porkies he told in this complaint. And respectfully submitted, Jose DeCastro. Well, 3 hours and 3 minutes. Longer than I wanted to spend. Not as long as I expected to spend. So we'll call that a win, although I did kind of skim over the counts, the causes of action, because they're nonsense. So yeah, basically, I think it's good that I am done because my voice is shot. So with that, do all the YouTube-y things, like, share, subscribe, bribe your friends and family to do the same. I will hopefully see you tomorrow to do the motion to dismiss. Should be good. From what I've seen, Craig Anderson does not hold back. So thanks for joining me. I will see you tomorrow. Bye-bye.